Joining me on the panel today are Judge Jim Edwards and Judge Carrie Ann Wozniak. Good morning to you guys. We'll call the case. It is case number 20-2684, Schreiber versus Schreiber. This morning, it'll be 20 minutes of argument per side. Ms. Jenkinson, you'll be first as the appellant, and we'll assume that you would like 5 minutes of time for rebuttal unless you tell us differently. And with that said, ma'am, you may proceed.
Thank you, Your Honor. May it please the court. Your Honor, this is a matter, I represent the appellant, Mr. Drew Schreiber. This is a matter where, just brief background, parties were married April of 2011. Parties separated, entered into a collaborative marital settlement agreement in 2014. A final judgment of dissolution of marriage with minor children was executed by the court March of 2018, whereby the court bifurcated an entry of dissolution of marriage. Remaining issues were reserved upon. Essentially, the parties then entered into a stipulated final judgment in September of 2018, which resolved all issues and reserved ruling as to the issue of attorney's fees, which is what we're here on before today, Your Honor. The former wife then filed a motion for attorney's fees, and this was filed on October 11th of 2018. The former wife was represented by 4 attorneys prior to hiring subsequent counsel for her motion for attorney's fees. The 4 attorneys, only 2 of those attorneys' fees are at issue today in this appeal, and that would be the Green Family Law Firm and the Wheelock Law Firm. In regards, moving forward, Your Honor, and there was a hearing held October 14, 2019, a year after the motion for attorney's fees was filed. At this hearing, upon objection by the former husband, the invoices that the former wife attempted to submit of her former counsel were deemed inadmissible hearsay.
Ms. Jenkinson, there's no transcript of that hearing, correct?
Correct. There is no transcript of that hearing. There is, however, an order that was done by the trial court subsequent to the motion for reconsideration and clarification that was filed on April 28, 2020. And the ensuing order does state that paragraph 5, her attempt to introduce an invoice from one of her prior attorneys was denied.
How does the fact that there was no transcript, though, not end this case here? Because we don't know what happened at that hearing. And under Applegate, that would be an issue for an appellant here. Please tell us.
Understood. That is one issue regarding why we believe that she's been given multiple bites of the apple. I don't believe that it precludes the other issues that we're also raising pertaining to the second motion for hearing that was heard as well. But the order does reference the fact that invoices were kept out. That's paragraph 5. And although there is no transcript to reflect that, the trial court order does indeed state that as well.
Well, let me ask you, in the minutes, I think it's in the minutes, and there's an exhibit sheet. It mentions a summary of the wife's testimony as to her attorney's fees that were still owed. I didn't see that summary in the record. Is it in the record?
I'm sorry, are you referencing the minutes for the first hearing, Your Honor?
The first hearing, October 14th of 2019.
I don't believe that's in the record. I don't believe that was ever made part of the record.
Okay, and because there is no transcript, we don't really know what that summary is. It looks like the trial court did admit it into evidence, but we don't know what that is.
Specifically, I'd have to go back and look at the minutes regarding that, and I can do so after I reserve my time if the court allows me to go back and refresh my recollection on that. But I don't see that it was ever made part of the record, and I didn't see that it was in the court file as an exhibit. But if I'm incorrect, then I do apologize, and I can refresh my recollection when I get a moment.
Is there ever a situation where you seek fees in a family law case and the attorney doesn't testify either live or via affidavit where you can recover fees?
I believe that specifically regarding that, there still would need to be some type of substantial evidence for the court, Your Honor.
That's what I'm asking. What would that be, hypothetically?
Typically, you would have the invoices, you would have documentation, you would have other.
Right, Are you suggesting that somebody else other than the attorney, or theoretically somebody else at the attorney's law firm who could lay a business records foundation, could somehow authenticate those invoices?
And I do believe, Your Honor, that the trial court did state that there's ways of getting around it, like the business exception that you just referenced, but that wasn't
Right, but I couldn't lay the business records exception for Wendy Aiken's law firm. And I mean, I think we all agree to that. So I guess my question is, can you envision a scenario where an attorney didn't authenticate their invoices either via live testimony or via affidavit by somebody who was able to authenticate those invoices? Can you envision a situation where somebody else could do that and thus support an attorney's fee award in a family law case?
Your Honor, no, I would believe that that would be an admissible hearsay, which is why the invoices were kept out. You know, the fact that the former wife had two opportunities to call the witnesses. She had the opportunity to do a big business records affidavit. She didn't do any of that, Your Honor. And again, I believe by reading the transcript of the trial court, there were many ways that the former wife could have attempted to introduce the information, and just she didn't do so on two different occasions. And that kind of ties into one of my arguments, which would be, even if the court doesn't believe that this is a second bite at the apple, well, our position is that this would be a third bite at the apple, because she had the first hearing where she clearly could have introduced the exhibits, but she didn't because she couldn't, because it was deemed inadmissible hearsay. And that is reflected in the order that I just previously referenced on the motion for the rehearing. She then was given a second opportunity, despite the fact that, again, there's no record of this, but I did sua sponte object that it would be giving her a second bite of the apple. And that's referenced in my motions for rehearing. It's again mentioned in the second hearing when we had the second hearing on the fees, but the court did not view my position as the same. And therefore, over my objections on both occasions, the court permitted her to have these hearings. And the second time, again, she didn't bring any witnesses that actually created the invoices, didn't have any records custodians present or affidavits present regarding those business records. And if the court believes that this case would have to be remanded, that would essentially give her a third bite of the apple, because she now would be essentially, I'm assuming, attempting to utilize inadmissible documents that were viewed and by the court as for purposes of identification, but never admitted in. So therefore, documents that are not admitted in, but marked for identification, there's a case on point, Wolkoff, states that invoices that were identified as exhibits cannot be relied upon in the court as substantial evidence. They were not made part of the record, and therefore the record was devoid of any competent evidence supporting the award that the trial court ultimately made for fees. So again, I believe that it would be completely prejudicial to Mr. Schreiber, to the husband, a former husband in this matter, in the event that the court did attempt to allow the former wife to have a third bite at the apple. The reason why, and there's case law on point, the reason why that, sorry, I'm losing my spot here. Mace, another case on point, states that remanding for a new trial when the evidence is insufficient, there is not an extraordinary reason justifying a new trial seems to reward either or both a litigant's insufficient trial preparation or a strategic decision that it might be able to convince the court to admit clearly inadmissible evidence. Again,
it seems like from the case law that the issue isn't going to be a question of whether or not it's prejudicial to your client. I mean, of course it would be prejudicial to your client. It seems like the issue is going to be whether or not the trial counsel for the former wife introduced any competent substantial evidence over the course of either of those two hearings, correct?
Agreed. And I believe that that's why.
So if he did in either of those two hearings, then the remand is going to be to fix and complete everything else that he was missing. And if he didn't, then former wife is stuck, correct?
I do agree that the main issue, there's several issues, but one of the main issues is whether or not any competent substantial evidence has been provided, because it's
right. And if there was, but it wasn't sufficient, then I think the case law suggests that the remedy would be remand for what would be a third hearing. Is that correct?
Your Honor, although I understand the premise, the issue is that if the case was remanded for what would be a third hearing, there would have to be, I would assume there would have to be some very specific instructions pertaining to how that would happen, because if any new evidence is allowed to be utilized, then there is no other evidence, Your Honor. The invoices were the evidence. The invoices were the evidence that they attempted to, on 2 separate occasions, get in, and both times were deemed inadmissible by the trial court. So if the court does remand it for a third bite at the apple, to remand it would then allow evidence in that was already deemed inadmissible. So that's why I believe, Your Honor, that it would not be proper, because it would be giving the former wife the opportunity to use inadmissible evidence. If there was other evidence, then
I'm not trying to trick you. I understand that your position is that there was no competent substantial evidence to support a fee award that was adduced at either of these hearings. I'm just asking you if you concede the legal proposition, which is that if we disagree with you and think that there was some competent substantial evidence introduced at one of these hearings, then the proper remedy would be a remand for another evidentiary hearing. Do you agree with that legal proposition? I'm not asking you to concede anything about your case.
Understood, Your Honor. Again, I understand. Yes, I agree that would be the legal position. However, I do think that there would need to be some type of limitations regarding the types of information the types of evidence that the court could utilize at a remand. I would argue that no new hearing should be permissible at a remand hearing if the court found that was appropriate.
Do you have anything else that you want to cover, or do you want to cede the floor?
Yes, if I may. I guess since we've been talking about the competent substantial evidence, which is the main crux of all this, I would argue that for there to be competent substantial evidence, the testimony alone of the expert cannot constitute proof of the existence of the facts necessary to support the opinion. That's clear in arc and construction. Competent evidence needs to be admissible evidence. The rules clearly state it needs to be substantial, and it's requiring more than just a mere iota or scintilla of information. There must be a probative value. The expert, I would argue in this matter, was not able to do so. The expert had conflicting testimony regarding the hourly rates of the attorneys, of the multiple attorneys that the former wife had previously employed. There was rough estimates utilized in saying how many hours these attorneys had expended. There was numbers left out as to how many hours the paralegals had actually billed. There was contradictory testimony as to what the reasonable rate of a paralegal should be. At one point, Mr. Wheelock's paralegal was deemed to be reasonable at $275 an hour. Later in the transcript, it states $150 to $200 an hour as a reasonable rate for a paralegal, is what the testimony of Mr. Cushing was. There's a lot of conflicting evidence. There's rates that at one point he indicated one of the attorneys, Mr. Cushing, was $400 an hour. When later questioned, he stated it was $350 an hour. Then he said, I just don't know. When asked about the amount of time expended, Mr. Cushing kept saying, I don't know, without looking at my notes, which is interesting to note because upon the former husband's objection on multiple occasions, the trial court had to instruct the expert to stop looking at his notes, to stop looking at his screen. And once he was again at the last time instructed to stop looking at his notes, his testimony became much more unclear, much more uncertain. Which, Your Honor, I would state that these are estimates, these are guesstimates, and there's case law on point that the hours.
I think the bigger issue, just from my perspective, is how did the trial court know without any invoices what these attorneys actually did, other than quote unquote litigated a high conflict divorce case?
Agreed, Your Honor, and that was also part of the issue with the reasonableness. You must determine not just the number of hours, not just how much time is expended in the rates, but also the reasonableness. And that's the lodestar argument in Roe. And in the reasonableness, the Florida bar rules have very specific criteria that needs to be satisfied to the specific nature of the work that was performed. There was no specific testimony given by Mr. Cushing. He just generally stated, oh, it was a high complex case, there was some mediations. Great, but there was no breakdown provided as to what these attorneys billed. There was no specific testimony as to what was done. And at one point, I even questioned Mr. Cushing about duplicative billing, block billing, to which he admitted that these things existed in the invoices. Yet they were not left out. And when I questioned the trial court in the clarification at the final hearing, once the order was rendered, when I questioned the trial court about that, the trial court says, yeah, I don't know. I don't know if that was included or it wasn't included. But this is how, it seems to make sense. It's essentially what was stated in the ruling. We don't reverse engineer. There's case law on point. It's a 4TCA case, but it's very clear that, to get to the results of attorney's fees award, the court should not be reverse engineering. That is not appropriate to do in order to come up or fashion an amount of fees. And Your Honor, I'd like to reserve the rest of my time. Your Honors, thank you.
Yes, ma'am. All right, Mr. Pelzer, good morning, sir. You're recognized and you may proceed.
Thank you, Your Honor. Good morning, Your Honors, counsel. May it please the court. The central issue in this case is whether Drew waived all of these hearsay and competency objections by failing to make a contemporaneous objection to Mr. Cushing's testimony. Now, as Judge Wozniak points out, we really don't even know what happened at the first installment of this hearing, but even confining ourselves to Mr. Cushing's testimony at the second hearing, we have the testimony that came in without any contemporaneous objection. Yes, there were objections to the invoices themselves. The usual professional courtesies were not observed here with respect to billing and affidavits of the actual attorneys performing the work. But Mr. Cushing was permitted to testify as to the reasonable number of hours that were by two of the four law firms here and the range of reasonable hourly rates. Of course, the experts frequently testify in the context of ranges on rates, and that is recognized and approved by this court and others. And so the exact precision in actual precise arithmetic that is demanded by my colleague here, especially when the expert is deprived of the opportunity to review notes in the complex calculations that were involved here. Certainly
had those notes been provided to opposing counsel?
His notes, I do not believe they were, Your Honor.
Well, and he was refreshing his recollection from that. Isn't it kind of basic that if you're refreshing your recollection, your opponent's entitled to see them?
Yes, Your Honor, and that's
and you have not counted. You haven't cross appealed the fact that
that's
he
right.
was not permitted to use that.
On that point. That we're not contesting the judge's ruling on that. My only point there is that asking for the expert to memorize the precise calculations and then criticizing him for an inability to do so.
It would have been fairly easy if the invoices had been admitted into evidence through the proper predicate, then the expert could have looked at the invoices themselves, correct?
Certainly that's correct, Your Honor. They were kept out. As I said, the usual courtesies were not followed here, but the invoices are in the record.
That might have come as a surprise, perhaps at the first hearing that they weren't stipulated in. But after the first hearing, it certainly could not be a surprise or a shock, or I think the word you might have used is gotcha, that you had to actually prove up what was done and how much each attorney was charging. So it was not a surprise at the second hearing, was it?
I don't think it was a surprise, Your Honor. I'm not going to defend the way the hearing was conducted, but I believe the evidence that was presented was nevertheless sufficient to support the trial court's rulings.
Did Mr. Cushing have personal knowledge of any of that?
No, he did not, Your Honor, but he also, his testimony came in without any objection to its competency. And this gets back to what
on that particular issue, the operative family rule of procedure mirrors the civil rule of procedure on rehearing. And it seems like that rule says that if you're going to challenge the overall sufficiency of the evidence, contemporaneous objection need not be made if, as here, you're not dealing with a jury. What am I missing?
Well, Your Honor, the contemporaneous objection rule applies in any evidentiary hearing. I believe the sufficiency of the evidence issue doesn't have to do with the the simple failure to make an objection or the failure to preserve that kind of an error. Rather, it has to do with
Well, look,
whether
what the rule says, what the rule says is when an action has been tried by the court without a jury, the sufficiency of the evidence to support the judgment may be raised on appeal, whether or not the party raising the question has made any objection to it in the trial court.
that's
Or
right.
made a motion for rehearing.
And what that rule says is that when you do not have a jury, then motions for directed verdict are not required in order to preserve the error as to whether the quantum of the total evidence is sufficient to support a jury's verdict or a judge's verdict in a non-jury case.
If your preservation argument fails before this panel, are you stuck?
No, Your Honor, we are
Why
not.
not?
Because this gets on to the last point on appeal, and that is the proper remedy in the event that that evidence is not deemed to be sufficient standing alone. And that is that when there is some evidence, not necessarily admitted, but just in the record, that would tend to support the trial court's ruling, the correct remedy is a remand.
What is that evidence in this case?
In this case, Your Honor, I would look primarily to the evidence record sheets at page 522 of the record that shows that these documents were marked for identification. They were before the court, and we can look to those and see that there was some evidence here, and that is sufficient to justify a remand. That's the Colson case and the Chandler case. In each of those cases, there was inadmissible evidence noted to have come before the court or an unadmitted affidavit and documents in the Chandler case. And in both cases, the court looked to that evidence to say, we should remand here because this case isn't completely devoid of evidence. It simply wasn't admitted because proper objections were made. And of course, those proper objections can't be cured.
How many, if you don't do it, if it's not done right at this third hearing, are you entitled to 4, 5, 6 hearings? How many hearings do you get?
Ultimately, Your Honor, judicial discretion would come into play, but I don't believe that the simple one appeal here. And I realize that this hearing took place over the course of 2 days, but I would classify it as a single hearing spread out over the course of 2 days and not 2 separate hearings because
the subject matter was the same, though. It was not, sometimes you could have a bifurcated hearing where you do entitlement the first time, and either because of time constraints or unavailability of witnesses or stipulation, whatever, then you do the reasonableness of the fees later. But at the very first hearing in 2019, wife attempted to introduce some of the invoices and was not able to based on objection. So it's not like reasonableness never came up. Reasonableness was a subject of the first hearing and the second hearing, right?
The amount aspect did come up, Your Honor, but of course, as Judge Wozniak points out, we don't know exactly what happened at that hearing. What we do know is there are multiple issues heard by the judge that day, other than attorney's fees, other than entitlement to attorney's fees, and other than the amount of attorney's fees. What I think we could conclude from that is the judge just ran out of time. And certainly that's a reasonable conclusion from the face of the record.
So to make sure that I understand your earlier answer, what you're saying is that for the sake of, if we agree with you and we remand for a third hearing or a second hearing, whatever you want to call it, another hearing, then the competent substantial evidence that has been adduced by trial counsel in this particular case is solely the exhibits that were marked but not entered.
Actually, no, Your Honor. The Martin case, which is relied upon extensively by my colleague, was a remand case where what happened was the expert testified, but no one else did. There was no authentication for the facts to undergird the expert's opinion, pretty much what we have here. And that was deemed to be sufficient to justify the remand.
You're talking about Morton?
Yes.
Okay.
Yes. And so that's an example of a case where the remand rule applied without any evidence from the attorneys performing the services and only some testimony by an expert unsupported by that factual testimony. There are a number of other cases that we cited in the briefs that would support remand in a case like this, even if we completely disregard the evidentiary value of Mr. Cushing's testimony. For example, the Diwakar case, the court characterized the evidence as being meager and only going to some of the work that was performed by the lawyers. And there also noted there was no evidence at all of the timekeeper performing the work or the number of hours that were presented. And yet the court found that a remand was appropriate under those circumstances. The Wagner versus Bank of America case is similar to the Colson and Chandler cases we discussed earlier, where there was an affidavit in the file, but it wasn't admitted, and presumably properly so. And yet the court found that the affidavit alone, an unadmitted affidavit, was sufficient to justify remand. Similarly, in the Black Point case is very similar to the Diwakar case. And there was insufficient detail provided about the hours, the work, and the rates. And yet the court found that this insufficient evidence would nevertheless support a remand.
So in those cases, the other side had filed the invoices. Are you just not drawing any distinction? Because it doesn't seem like trial counsel filed these invoices. It seems like some, or we don't know because they're not part of the record, some of them might have been marked for identification. You're
Yes,
urging us to basically read that as the exact same thing?
Yes, Your Honor. There's really no distinction between gratuitously attaching a document to a motion, which would otherwise be, of no evidentiary value standing alone, and then proffering that document at an evidentiary hearing.
Is one potential distinction being that if it's filed, it's going to be served on opposing counsel, and if it's just marked for identification, we don't know whether opposing counsel's ever seen it before?
Well, there was no objection made with respect to violation of any pre-hearing procedures or failure to properly provide these documents. The objection.
What proper objection could there be to marking an exhibit? How, if I'm a trial judge, could I prevent somebody from marking an exhibit?
Well, that's correct, Your Honor, that simply marking the exhibit is something that a court normally does. But if you look at the transcript in this case, there was no surprise objection raised to these documents. The objection raised was hearsay. And so there's no surprise indicated or any reason to believe that there would have been any surprise by relying on these documents. And so under those circumstances, Your Honor, I think it's the same as if you gratuitously attached it to your motion for fees. The situation is the same. The documents are in the record and they are sufficient for the court to rely upon. And frankly, even if there had been surprises, we're talking about a remand, that surprise would have no impact on the remand. So I don't see a distinction there, no, Your Honor. We could go through the other cases as well, where in some cases where there was where there even contradictory evidence and the expert witness made up facts that weren't supported by the record. That's the Trumbull case, and they still remanded for rehearing, or evidence was kept out for tactical reasons in the Tucker case, and the court still remanded. So the remand is very strongly favored in these cases, and it's because the attorney's fees, it's particularly in a domestic case like this, we're not talking about commercial opponents here. There's no gamemanship involved here. This is supposed to be a family court, and the remand should be all the more be supported by the court, and the default position, I would say, if there's any.
Let me ask you the same question I asked Ms. Jenkinson. Can you envision a situation in which, in a family law case, an attorney's fees award can be made, ordered by a court, without an attorney or somebody competent to testify on the attorney's behalf authenticating the time records?
Well, this instance would be one of those cases, Your Honor, where the evidence came in that may have been not competent, but was unobjected to. So
set aside the preservation.
Leaving
Just
aside
answer the question. If you could answer the question for me substantively, I'd be grateful.
All right. So substantively, Your Honor, the rules require that there be testimony and evidence on the work performed and the hours that the work took, and then the expert testimony on whether that was reasonable and what the reasonable rates would be. So I would say, Your Honor, no. If there's simply no evidence and there's no reason why there was no evidence, then there would be no award of attorney's fees.
Does the attorney have to testify to it though?
No, Your Honor, that's clear.
Who could authenticate what an attorney did other than the attorney or somebody with firsthand knowledge? For example, let me just suggest that there was a mediation that took place in, say, last summer over one day, and the time entry from the attorney. And let's be clear, I'm not attacking the credibility or competence of any of the attorneys in this case. Say it said one attorney on that one day billed 43 hours for the mediation. How could anybody other than, how do we know what the attorney did in that particular case? Say it's 23 and a half hours. Without the attorney authenticating that, how do we know that that's not a typo or not just outright false?
Well, if there's no authentication of the records at all, then that would be a situation where you look at the records and say that this is patently incredible. I certainly have heard people saying they worked around the clock that day to get the deal done because the closing was the next day and they couldn't put it off, and so they pulled an all-nighter and they billed for all 24 hours that day. But I would say that's probably an unusual circumstance. And certainly a 43-hour day sounds like either a typo or they bunched a bunch of time into a single time entry. But be that,
we don't have any idea. We don't have any idea in this case what Mr. Cushing looked at, as it related to enumerated entries. We have no idea.
He testified that he reviewed the bills, Your Honor.
That's great.
But he's yes, he is not competent to testify as to the bills, but there was no objection made, and so that's what we were relying on there. And even if you decide to allow the late raising of the objection on appeal or on rehearing, there's enough evidence to support a remand to cure these technical deficiencies. And in a case like this, where we have a vast disparity in the ability to pay and a very modest fee award here, a reduced modest fee award of just a little over $50,000 for this covering most of this multi-year divorce. We suggested to this court that discretion should be exercised in favor of the remand. We ask that you affirm, or in the alternative, vacate and remand for a further evidentiary hearing.
All right, Ms. Jenkinson, I think you have a little bit less than 5 minutes left. Go ahead.
Thank you, Your Honors. Just briefly touching on the last statement that it was a reduced fee award to any extent that has any relevancy here. And there is testimony, and it's in the transcript, that the former husband had paid a substantial amount of fees to one of the prior attorneys that are not subject for part of this appeal, to the tune of just under $30,000. So I would disagree that this was a very reasonable fee award. But again, that really isn't pertaining to what the issues are before the court. Again, there's Elser is on point that the objection to hearsay is not waived by it being brought up subsequently at a motion for rehearing. There's the Florida Rules of Procedure that the court was referencing, Rule 1.530, which I believe is very on point for non-jury cases. This is a non-jury case, a civil non-jury case. The cases that the former wife has mentioned, or majority of those, are not non-jury cases. They are trial cases with juries involved. So again, I think there is a clear distinction in regards to that issue, and I don't believe that there's any prejudice to the former husband by not having raised that at the time of the hearing. In addition, the expert can testify in order to make his opinion. He can review these statements to make his opinion, but again, it's the opinion itself cannot be the basis to lay this foundational evidence for the court to consider. That's what, again, I referenced earlier in the Arkin construction case. The expert's opinion cannot constitute the proof of the existence of the facts necessary to support the opinion. And it is our position that there are not sufficient facts, that there is a record completely devoid of any substantial competent evidence for the court to award the fees. And therefore, that is why we're also further arguing the fact that a remand would not be appropriate, since there is, again, no evidential value to what the expert testified to. The expert testified, just real quickly, we mentioned a little bit about what he reviewed. Right, he reviewed invoices. The former husband specifically asked during direct, did he speak with any of the former attorneys about any of the billable entries? To which he stated he hadn't. He had a brief 1-minute conversation with one of the attorneys regarding a document that he hadn't received, and that was the extent of that. So the expert did not have personal knowledge, let alone secondhand knowledge. I guess the invoices could be secondhand knowledge, but again, those are billable invoices, which bottom line were not admitted into evidence. They were deemed inadmissible. Yes, they were marked as evidence, but again, as we stated earlier in the Wolkoff case, marking an item for identification, if it's not admitted into evidence, does not deem that item or that exhibit that as a reliable form of evidence. It's marked for identification, Your Honor. It's not part of the record. That is not admissible evidence for the court to consider.
What do you suppose, if anything, the difference is between marking something for evidence and filing it? So if we look at Morton and it just says, all right, you know, the counsel in this case, it filed the invoices. What's the difference between that and marking them?
For marking them for purposes of for identification, truthfully, Your Honor, I believe the reason why that was even done at the request of the trial court was essentially the former wife expert could have attempted to use them to refresh their recollection, but they didn't, which I still would have objected to as hearsay, but regardless, I believe that was the basis as to why they would have marked them for identification or attempted to mark them for purposes of identification for that purpose. But that wasn't even something that the former wife attempted to do. Again, keeping that evidence, which again would have been objected to as hearsay, but I believe that was probably the point of trying to attempt to mark it for purposes of identification. The former wife had already attempted to use the evidence at the first hearing, tried to use it again at the second hearing, Your Honor. I don't know what the clear distinction would be between marking it and filing it as evidence. But regardless, Your Honor, it wasn't evidence. It wasn't made part of the record. And yes, it was marked, but there's case law on point that says that even if it's marked, that is not to be construed as any evidential value.
All right. Thank you both very much for your presentation. We'll take the case under advisement. Have a good rest of your day. We'll be adjourned.